So welcome to the panel that is hosted by noyb, none of your business, but plenty of ours here in the room today. We're going to look at GDPR and collective redress. The idea is that we're going to look at the challenges in representative actions. So we're going to look at the procedural, the financial, and the jurisdictional hurdles. Potentially, if we've time, suggest some remedies to what we see as the hurdles here in this panel. The Collective Redress Directive was supposed to be this great game changer for GDPR litigation, but in reality we haven't really seen it play out like that. We haven't seen this big boom in litigation. So we're going to look at what the situation is today, what the complexities are, and how we can deal with those. We are seeing some class actions on GDPR violations, but we want to look at what's coming up in the next few years. Will GDPR move from the DPAs back to the courts, and what's holding back the litigation? I'm sure you all know the background, but Representative Action Directive was adopted in 2020, very slow implementation by the member states beyond the deadline of December 2023. Today, however, most member states have implemented it, except Spain and Luxembourg. GDPR naturally included in the scope of the directive. So not only for profit organisations, but also those who have been designated by the national authority as so-called qualified entity, and that's relevant for us here from noyb, that they can bring these actions. So injunctions, the cases that need to be mandated by an individual where a qualified entity can get a court to prohibit any unlawful action by a company, and then the redress claims are the cases where the rights of individuals can be grouped into one case. We'll talk a bit more about those in detail, where they're standing up, where they're falling down, and what has happened so far. Why do we not see more of these collective actions? And again, these challenges, which are particularly in the context of procedural and material law rules, a lack of funding, and then we're going to touch on at the end as well the complexities of private international law. Now, all that said, I'm Jennifer Baker. I'm a journalist and presenter based here in Brussels. I'm going to moderate the session, so I have all the questions and none of the answers. Our excellent panel here will have most of the answers, we hope. Charles Demoulin is Chief Investment Officer from Demoulin, a funder, very far at the end. Next, Professor Ianika Tzankova from Tilburg University, Rubicon Impact and Litigation. Max Schrems is chairman of noyb, and right here on the end next to me, Sean O'Sullivan is a barrister from Ireland, a practicing lawyer. If you're not familiar with how we like to do panels at CPDP, we tend to break them into topics. So we're going to break ours into 4 particular topics. We're going to start with the representative actions against GDPR infringements. Then we're going to look at the practicalities and complexities of collective actions. We will then look around the funding and financial barriers, and finally we will touch on private international law. And after all of that, we'll try and bring together your questions if you have them for our panel and if we have time. So I'm going to sit down and I'm going to get started. Max needs a clicker. Okay, right. But let's start, Sean, let me start up with you at the far end. We're going to focus on the representative actions against GDPR infringements. Tell us a bit about the kind of claims and what you typically bring as a claim in collective redress.
So, no representative action has been brought in Ireland to date. That will change, I think, in the very near future, and probably over the next 6 months you'll see somewhere between perhaps 2 and 6 representative actions brought in Ireland. At the moment, there are only 2 qualified entities, so as most people in the room will know, you have to be a qualified entity to bring an action. You can be qualified in any EU state and bring a cross-border representative action in another country, but in Ireland there are only 2 qualified entities. One is noyb and the other is the Irish Council for Civil Liberties. It's perhaps notable and surprising that the National Consumer Agency hasn't sought to become a qualified entity, given that it's supposed to protect the collective interests of consumers, but there we have it. I think in the first instance what we will see is a representative action for injunctive relief against one of the big data companies for one of their ubiquitous actions, let's say data transfers, real-time bidding, the aggregation and analysis of data across platforms, something along those lines, because I think it is easiest to identify an infringement and ask a court to stop it then move to asking a court to examine, well, what damage has been suffered. I know we're going to come to the particular issue about how we want to assess quantum of damages, But I think in the first instance, that particular chestnut is left to be cracked on a different day. I think in Ireland, we need to concentrate on the procedure. So again, Jennifer talked about the slightly scattergun implementation of it. Of the 27 EU countries, I think the Commission had to open disciplinary proceedings against 24 of them for a failure to implement it. So there was really no enthusiasm amongst the member states for this. And so in Ireland, we had the Act. It was introduced 5 months after the deadline, but it did come into force in June of 2023. But we still have no court rules as to how these proceedings are to be conducted. And so there is a certain enthusiasm to let things develop organically. But as a result, that's going to cause confusion and delay in Ireland, which means that the larger tech companies who are based in Ireland will have more time than perhaps we would like to get their act together. So it's going to be slow, but it's going to happen. In the next 2 months, you will certainly see 1, perhaps 2 actions in Ireland, and I think by the end of the year, 3, 4, 5 maybe. But they will all be injunctions in the first instance, because that's, in terms of setting down procedure, that's the easiest thing. There's also, in terms of funding, which Charlotte is going to deal with, slightly less onerous conditions on a qualified entity when bringing an application for an injunction as opposed to redress. The level of proof of your funding and the interaction with the funder aren't quite as onerous. And so when we're starting to kind of lay that road, the less complications, the better. But that's how it'll start, I think.
Ianika, redress claims. So we've got this opt-in or opt-out basis in terms of the individuals who can be included in it. So from your experience, and tell us about the main features in terms of the GDPR violations and redress actions, and what you're seeing in terms of opt-in or opt-out, and a little bit more broadly as well, because you're not focusing on the Ireland case.
Yes, so thank you. I get quite often the question, how come you have, relatively speaking, so many privacy and data protection cases in the Netherlands? And I think to understand where this comes from, one needs to have an idea of the collective redress tradition in the Netherlands. We have had collective action since 1994, only for injunction and declaratory relief, and quite active privacy organizations, privacy protection organizations, who were bringing these cases already in the past for injunction relief. So, and our regime is applicable in all areas of law. It's not limited to competition or privacy or consumer or anything like that. It's a horizontal approach to collective redress. So it means that our judiciary is used to deal with it. It means that we have lawyers that are specialized in it, and we have organizations that could be long-standing or ad hoc established. So when we got the new collective damages action regime in 2020, that allowed for collective damages actions on opt-out basis, it was very logical that quite a big portion of the claims that were initially brought were actually privacy and data breach cases.
Well, Max, you are representing a qualified entity, so are you focusing on injunctions or redress? And if the latter, how are you looking at damages?
At both, obviously. So we're just starting this year as well. The same thing, Austria took like, I think, 1.5 years longer to implement, and you need to become a qualified entity. It takes half a year as well. So there's a certain delay when you actually start. We're now looking at the first injunctive relief. I mean, we just last week sent out a cease and desist letter to Meta on the Meta AI training data discussion. So that could be a first one. And we're right now planning, but I can't say too much, a redress case in Austria as well. And that gets into the question of, in a redress case, where you just don't tell a company stop doing in the future what you did so far, but you actually say, I want to have damages and I want to, you know, in consumer cases have other claims, but in GDPR claims, it will largely be non-material damages in reality. That is quite interesting as well, because for these cases, other than, you know, normal consumer rights cases, they're very, very similar. Like you have, you know, 400 million Meta users in Europe, to stay with that company, that probably all had the same breach, more or less, or the same violation of the law. And that scales enormously. So that's quite interesting. And the big question so far was always what's going to be the financial damage. So part of it is unjust enrichment that we look into as well, which is how much profit did they make? Can we take the profit away? And the other one is really damages in itself. And there it's interesting that there was tons of cases. I think half of them came out of Germany usually of can we somehow not have the damages, but the Court of Justice was very specific to say, yes, you need to have some damage. You just don't get money just for the violation of the GDPR, but you don't have to sit at home and cry 5 years to actually get some money here. And a good case that we look at, for example, is the Bindel versus the European Commission, which was this one IP address sent to the US without the legal basis. And there the General Court at the European Union said that's 400 euros. Yeah. So we generally take a view it's probably in the 3-digit realm, most of these violations, unless it's totally crazy. But that, if you scale it up with 1 million people, suddenly gives you cases that are quite enormous compared to anything we're used to. Also, as an organization, you know, for us, that's a totally different dimension that we may work in than we did so far.
May I just add one thing to that? So I mentioned that in the Netherlands we have this tradition of long-standing organizations like noyb or ad hoc established foundations for one particular breach or infringement. And a very interesting trend that we see since we have the new law introduced 5 years ago is something that is a form that's in between. So organizations that have been established ad hoc for particular breach or particular claim and case, but with the ambition to become long-standing organizations specialized in actually bringing this type of collective actions on a more regular basis. So I would be interested to hear from you, Max, how you look at this development, whether you see this type of organization as being a competitor in a way to what you're doing.
In really short terms, we usually don't think about competition. In that sense, there's so much illegality in the GDPR that we can probably have 100 organizations and everybody still has something to do. So we're usually happy with anybody that does more cases. And in reality, I think what's going to be a question is the quality of the litigation. In a sense that there are, the big worry about the ad hoc is that, you know, some law firm gets an ad hoc that just does something crazy and then that harms the overall sphere to be like, you know, collective redress, like a bit in the US, oh, that's class actions, only law firms make money, yada, yada, yada. That's a bit our systematic worry, that this message gets out sometimes. But that depends on the organizations. They're great ad hoc vehicles that really make great jobs. There's a bit the assumption that if you're in it for 20 years, you probably have a bit more of a reputation you need to worry about. That's a bit our take, but so far we didn't see that too much, to be frank.
Charles, let me bring you in because I'm going to come back to Sean as well on this particular point. But, you know, as a funder, what do you think is realistic, or are there claims that you would shy away from?
Well, I think it starts with a good story. That's I think that, and that's also how lawyers approached. I think it's start with a good story, and to go in the same direction as Max just mentioned. We tend to shy away from what I would describe as a lawyer/funder-driven litigation. So I think for a funder, obviously, it's about redress, because it only makes sense for a funder to invest in litigation if there can be income being generated by the litigation, which you don't really have with injunctive relief. But I believe that one strong argument in order to convince us to fund a litigation related to privacy rights is who is behind it. And do we think that the court will be convinced that this litigation to be funded addresses a need in society, even if it's a group, society more in general, but if it's a group. We have been sometimes approached by people who say, oh, we have a great business opportunity here, would you like to fund it? But I think the courts will tend to be more conservative if they have the impression that you're asking them to certify a collective action that will essentially lead to income for the lawyer/the funder. So it's all about the story and really saying it's people here in the room who have been affected.
Sean, you wanted to jump in.
Sorry, I was just going to say, just on the ad hoc thing, this is part of the reason. So to be a qualified entity, so to bring one of these actions, you have to be active in the area for at least 12 months. So that's almost cut out as a result of the provision for that. And then secondly, will there be competition? You can also bring joint representative actions between two qualified entities. So actually it encourages cooperation more so than competition in that space. Are there just the 2 points I want to make on that?
Well, actually, that is indeed what we see in practice in the Netherlands as well, that this specialized organizations that started as ad hoc but develop into more permanent players are collaborating with the longest-standing organizations. What we also see is that actually some of the longest-standing organizations in the Netherlands are actually hesitant to act as claimant in collective damages actions, and they prefer to support such an ad hoc organization. So in that case, indeed, join forces, but in a different type of collaboration or cooperation. Can I add just something more on the funding aspect, again from Dutch perspective? Since we have an opt-out regime since 5 years, that brings an increased responsibility on the organizations that represent the data subjects to bring about the best possible quality of representation, and that is called certification proceedings or admissibility proceedings. The court need to review all these tests and requirements that they qualify to properly represent. One of them is representativity requirement. And in one of the first cases, because the courts also had to get used to these new proceedings, we had case law that basically required the organizations to sign up individuals before they would start the case. Now, for many of you who do not have an opt-out system, this may sound logical or not a big deal. But if your system has been set up as an opt-out system, and then you start asking at the beginning to be signed up of individuals, that is basically turning an opt-out system into opt-in. So one of the first cases was about this question, and it is still before the courts. We still don't have a final answer, but it will be determinative, in my opinion, about the success of our regime in the future.
Well, I think we're moving on into topic 2 there, which is the complexities, which I do want to talk about. But before we move finally into that, can injunctions be a successful tool to halt GDPR violations, injunctions in particular? Sean, just to close out this topic in terms of specifically GDPR.
Yes, I think, and specifically from an Irish perspective through the EDPB, the idea of individual complaints, or even Article 80 bodies bringing individual complaints to any of the DPAs, in particular the Irish DPC, has proven to be a spectacular failure. Because whatever arguments you make, they're parsed inside the authority, and then the data controller is given so much more leeway to respond, and then it goes to the EDPB, and the complainant has no right of interaction with the EDPB. So the EDPB will then make a decision under the cooperation consistency mechanism, and it'll come back. So it's several degrees separated from the original complaint, at least in the representative action. You can bring the direct action on behalf of a whole swathe of consumers. You can prove general infringements of the GDPR, and you can ask a court to make it stop. And I think that it gives much greater control, and because it's a collective action, rather than simply an Article 80 body bring it on behalf of one or a very small number of affected data subjects, it gives it much greater weight. And I think once you get through the hurdles and it becomes admissible action, I think it has the potential to have a far greater and indeed faster impact than any of the complaint mechanisms we've seen so far.
So we've already touched on some of the practicalities and complexities, but Max, talk us through, the reality as a qualified entity of actually collecting claims and operationalizing Collective Redress Directive.
That's our biggest nut to crack, because in the system, basically the qualified entity is after all kind of the centerpiece, so to say, that has to find a lawyer here, the funding there, and the people on the other end, so to say. And especially in the opt-in system, that's quite a big one. To give you an idea, I made a little class action in Austria as a single person, and we managed to automate it to an extent that it worked quite well. And we signed up, I think, 25,000 people in 6 days, and I managed it from my own computer. Now, that is a bit like the thing that we want to go to, just like, you know, as an organization, you have much more resources and hence can have way more people you sign up. I internally always joke to say, you know, if we have 1% of Meta, for example, users for whatever Meta violation, there's a long list the Court of Justice had so far, that would be 4 million people to manage. And typically, when we talk, you know, when we talk in Ireland or the UK, where there's sign-up companies that do that, they oftentimes have costs of 50 to 100 euro to sign up one person. So just to pre-finance, for example, that is insane. You would have, you know, 400 million euros just to sign up the people and know that they're a real person. So what we work on a lot is automating that. So we basically build a app, for example, where people can sign up, and we do the first test run probably in a week or two, or probably 3 weeks in Austria, to, for example, have EID so that people can automatically sign up and say, I'm really that person, not Mickey Mouse. I can then, for example, automatically connect to the individual, especially in the digital sphere, we can connect to the individual device that they used or the service that they used to say, do they really have an account there? And that's what we work on. It's a shitload of work because in theory that all sounds easy, but then if you start, for example, with EID all over Europe, you realize you have, I don't know, 30 EID regimes and you have to try to interconnect with all of them. So there's a load of work there. That all being said, I think there is a huge opportunity there. To get that up and running, and a couple of factors play into to kind of get that done. And all of them will probably also get better the next couple of years. Best example that I had is identification. If we move on to more digital identification, which a lot of member states do, then suddenly, for example, in Scandinavia, you can EID 90% of the people. And then it's just one click to know that person is a genuine real person and that we can represent them without having to check passports and so on. So I think there's a lot of that stuff that we work on right now, but we're just going to see it now happening and working out. But it's going to be really interesting how that works. Last but not least, what's interesting is also the whole PR part of it. Like, how do you even get to people? How do you get them to sign on? And for example, in the first case we did in Austria, it's interesting because we had a mix of people that really were interested to get this case done, like politically interested. And then there's the potential money you can get out of a case that's also an interest. But what was surprising is that we got a lot of emails by people saying, I don't want the money, donate it to something, just bring this case. So there's a lot of these dynamics that we also have to look into, for example, for word of mouth propaganda, where just people say, hey, I'm joining this, do you want to join this too? Versus what we saw in some countries having, I don't know, billboards on the subway, because you're not going to pull that off throughout Europe. So that's all the thinking that goes right now into actually getting something up and running like that. And it's really fascinating because it's like, as a lawyer, nothing you usually work with. It's a lot of like management, really. But if we get that up and running and it works well, that could be extremely powerful.
Yeah.
Yeah. So as a someone with background in collective redress rather than GDPR, I must confess, I'm listening to you, Max. I must say this sounds so insane to have to. GDPR, privacy, to have to require to sign up people to bring cases that by their nature, you should stay away from it. And my statement would be that if you want privacy and GDPR cases to work, in reality, you need an opt-out, really. And I hope I will be proved wrong. Thank you. I don't know who that is, probably one of my students. I hope I would be proved wrong, but I really cannot imagine how that would properly work. Certainly, in these cases against big tech, that, as we all know, are very complicated from factual, from legal point of view, require huge investments, and that is what we see as becoming an issue now in my jurisdiction. This collective damages cases, our regime is rather expensive because certification is an expensive. I mean, opt-out does come at a price, so you need external funding. All of the damages cases that has been filed in the Netherlands to date, not just the privacy, but all cases have been all externally financed, and funders want to see. I mean, injunction is obviously very understandable and useful, and it's always part of the claim, but it also wants to see damages actions. They want to see as part, otherwise it's not fundable.
Giles, is that true?
Well, yes, it's a fact. I mean, it's, and I fully...
And please elaborate on why.
Yeah, sure. But first, I fully concur with what Ianika just said. I mean, I would like to show you, explain to you that it's not only about privacy, it's about like climate change. To me, and these are the two, because it's, you could say, privacy is part of a sound environment in our interactions in society, but we also have our environment on Earth, and there, it's, I mean, asking people to opt in order to be compensated while, I would say, by necessity, they have been harmed, like in environment. If you don't have the opt-out, that's not going to work. It's very simple. And for us as funders, I mean, maybe I could take one example. If we were talking about a breach of privacy or a data leak because of a hospital have been hacked, or there was an identified public of people whose extremely sensitive data have been leaked or would be out there in the open, I think the amount of damages per person would be that high that opt-in could maybe work, but these are only the exceptions. And for us, if we would, I mean, if you come and say, hey, we want to do an opt-in collective action because of a breach of GDPR, but the amount is going to be probably limited per, as we heard now, 400 with the European Commission, and then I think the big EA also was it 250? So when we just, well, you've just heard how much work there is. And we are being footed the bill, which is fine. This is our role as a funder. But if I see, oh, on one side I have to spend millions of euros or pounds for that litigation, I need a huge multiple of this on the other side. But then if I start running the math and say, oh, well, 200 euro per person, how many people do we need? And that becomes a chicken and egg. Then we'll say, guys, come back to me once you've signed up all these people. Yeah, but in order to sign up these people, we need your money.
Yeah, Max.
If I may jump in on that, we basically, I'm less pessimistic, but probably I'm too optimistic. I think fundamentally it goes down to numbers. And what was interesting when we did the one in Austria, like for example, we automatically had people log in with Facebook in that case, so we could really prove that. And it's interesting once you get the sign up down to a couple of cents per person, or €1 per person, because you can automate it suddenly, then to claim the innovation word that usually is used on the other side all that much, we can maybe innovate our way out of that trouble, and that is at least where we're working on. But that's an enormous task, I'm fully aware, but it's quite a powerful one as well, because then these mathematics suddenly become very different.
But then it's transferable case by case, and you accumulate knowledge. Sean, Ireland's particularly relevant a jurisdiction for the big tech cases. I mean, is that a factor in cost as well as complexity?
I mean, legal costs in Ireland are kind of what they are, but I mean, you've run 2 cases now on a no-fault, no-fee basis that have both been, one would call them reasonably successful cases. And so, I mean, there has been a certain willingness among Irish lawyers to do that, but the problem becomes when you sign up to these sort of cases, the volume of work involved and the number of lawyers that are active on the other side almost makes it impossible for lawyers to take them on a no-fault, no-fee basis. But so you need funding. And what you were talking about, Charles, kind of the skepticism around what we call the moral hazard of litigation funding, that you're profiting from somebody else's damage and you're limiting their recovery as a result. But actually, the moral positive of funding is in the deterrence factor of it. So injunctions are all well and good, but what they do is they permit unlawful activity up until the point of the order, and then all the profit has been made, and they go, we'll find something else unlawful and profitable to do. And there's no, and there's no, to use my nephew's phrase, no takesy-backsies on the money that has been made. So you need that, you need that deterrent effect of you're not going to make any money out of this. I mean, you talk about the unjust enrichment. I have an issue with that because restitution means everybody goes back to where they started. But of course, it wasn't the data sellers haven't lost any money. It's arguably the businesses that have paid and made money, so where does that go? But if you were able to identify how much money they have made and that had to be paid over and then they were fined, then all of a sudden they are actively losing money on unlawful activity. But an essential part of that is litigation funding, and we need to prove that we can obtain redress at reasonable levels at low cost, and this is where the €25 maximum to sign up comes in. Can we get to a point where that becomes feasible, possible, or even in that ballpark where we can do that?
Just to sidestep away from the funding issue for a moment, I mean, Max, what else needs to be, and we're talking about, if you like, user sign up, what else needs to be in case, you know, admissibility of action, are there questions around similarity of claims from jurisdiction to jurisdiction, any other factors on a practical level that you need to be top of mind?
The ones you mentioned are there, but I think in our litigation it didn't pop up all that much. So there's, for example, discussion is like, is everybody really had the same trauma, so to say, because you may have super sensitive data in your account and the other one not, and how much can you differentiate? I mean, one option is that you just go for the common denominator. You just basically say if you have more damages than the class action will do or the collective redress, then that's up to you, and we're not going to go into these details because we can just not manage it. And most people would just say, okay, then my little extra €10 I would get are just done, but I don't have to deal with it. The other option, if you have larger groups, is that you do subgroups. So you start saying, okay, we have group A that has that issue, and then we have group B that had the additional factor of whatever it is, sensitive data, as an example. And then you can basically have two groups and even two claims potentially. So there is these options. Or one issue we ran into, depending on the country, there are certain time periods where you have to sign people up. Now, a lot of people will only realize the litigation goes on once it's filed because they read in the news, and then the sign-up period is too short. So one option is to also, for example, do multiple classes that you just bring every 2 weeks or every 2 months or whatever, and then most courts will merge them back together for litigation, really. So there is a lot of ways that you can play with that, but none of that is there's not that much experience in practice, and we'll have to figure a lot of that out in reality.
Charles.
Sorry. Yes, maybe because the idea here is also to look to the future, right? And to innovate. On your point about the losses, because this is obviously something we carefully review as a funder, I'm going to throw maybe crazy ideas, but sometimes one of them could be useful one day. First, well, you have the solution in the CAT claims, competition law claims in the UK, the CAT, the Supreme Court said, aggregate award of damages, the broad brush, that could be one solution. Two, let's think about something like they do in competition law at the European level, infringement by object or by effect. There are certain breaches of competition law that are everybody agrees in the market or the academic world or anywhere, it necessarily leads to a harm, which should make it easier for the victims. In that case, it's usually the European Commission saying, I don't need to demonstrate any effect. By its very essence, this is harming competition. Maybe we should think about the same in privacy. The power of the courts to estimate losses. Again, in competition law and antitrust litigation, that's what you see. Let's think about securities litigation. What was developed in the US is the fraud on the market theory, so that rather than telling each and every investor, yes, you know, well, my own loss as an investor was that amount because of X, Y, Z. The courts, even the Supreme Court in the US said, well, let's deal with the fraud on the market because the misrepresentation made by the defendant had an impact on the stock price more broadly. Why couldn't we do the same about privacy, breach of GDPR? Why shouldn't we hire psychologists? Yes, but I mean, for fraud on the market, you used experts, corporate finance people, investment banks to assess and explain why it has an impact on the stock price. Why can't we come with well-reputed psychologists to say, with this kind of breach of privacy, this is what the common human mind is reacting to this kind of violation. I think there are definitely ways to do it, I believe.
I'm glad you said that, Charles, because I have in my panel instructions, panelists will share their insights on the effectiveness and propose reforms. So, Max, proposed reforms or propose ideas that can make things better.
In between reform and what we already have, if we read, for example, the Austrian Postal Service case, that was quite interesting that they basically went back to this idea of efficiency and equivalence of national cases we already have. And we have the problem with, like, for example, the amount of damages in other non-material damages as well, like how much is a broken bone is discussed since 300 years. And what we went towards is, for example, an objective assessment, and that can take a lot of the complexity out of the litigation, because like Mr. Bindel did not have to cry in front of the general court, you know, how much he really has a suffrage. He just said, yeah, roughly 400 euros. We're probably going to generate that case law over the next couple of years where we can say, okay, ballpark, we know it's in that realm. And that can take a lot of this complexity out, that each individual actually has to be reviewed. And that's what we did in all other cases. So I'm a big fan of, like, we still had to do Roman law in Austria 2,000 years ago. A lot of the problems aren't new. Typical example there is that we also have that in media cases. Like I always joke, there's these, you know, princess was photographed somewhere. The princess does not have to be in front of the court and cry. We just assume a general average princess will feel that and that much damage, and that's how we deal with it, because it's, especially if you have 1 million people, not manageable. And that gets to the effectiveness element of EU law, that in the realm of EU law that we already have, there's good footing to make these arguments, and I think that's where we would like try to go into.
May I also add one thing from practicalities, but then from the lawyer's perspective. What do you do if you are in a new procedural regime with a fairly new legal framework, the GDPR, and with development in case law that is a moving target, and every 2-3 months, half a year, you can expect another decision that you didn't know when you were preparing a case. So the way that or one way to approach that, and that is what I've also been doing in private practice, is obviously one thing is to sit and wait until the case law has evolved and developed. That's not probably a very wise thing to do, because a lot will happen until then. And another way is to try to set up and structure the claim as broad as possible in anticipation of what can happen, which could mean, with respect to damages, that you would not only claim for immaterial damages, but also for material damages, and that you should come with the surveys. We actually did have experiences with working with economists, with experts, and proposing surveys among consumers to demonstrate harm. And I remember a discussion we had with a barrister from the city who was consulting at the background, and we realized the tradition in England and Wales and on the other side of the Channel is very different than on the continent, where there it's a sign of a strong claim and a good claim to focus and be as narrow as possible, whereas on the continent, certainly in this area of law that is fast developing, we actually, if you want to progress, have to be to take a different approach. So this is how we deal that in practice.
Yeah, I'm going to give it to Sean. I mean, I like your GDPR, a law so new, it's already up for review, you know.
Yeah, we're so dynamic, data protection lawyers. So how would you deal with that? I think it was the US President Dwight Eisenhower who said he wanted a one-armed economist so that they wouldn't be able to go, well, on the one hand, but on the other hand. And lawyers do that all the time. They will go, well, if it stays like this, then this will happen. But if it moves, then this will happen. So lawyers will equivocate, as we do so well. But I think you have to do that, precisely because things are moving. I've been in cases where a judgment has come out in Ireland, and then the Commission is now changing the law to the exact opposite of what the judgment was. And so if I brought the case in 5 years' time, I would have lost or won, and vice versa, as the law changes, as we try to make the whole regime work a little better. But one of the things that you said about the, say, competition law breaches, it's so obvious. So there's a principle, res ipsa loquitur, which is it speaks for itself. So it's an action that so obviously causes the harm complained of that it cannot be rebutted, and the court simply assumes damage as a result. And then you get to the third point you were making, the court simply assesses damages as a result. And so if we can find something that's so egregious that it's a clear loss of control, and we try to get to a point where it's not necessarily the personal feelings the person had, but it's the risk to which the person was exposed, whether they were aware of it or not. And that then takes out this idea that we have to go through a subjective test. Did you cry? Did you weep? Did you wail? And then we have different categories of people who are entitled to greater damages. So how do we get to that point? And I think those two combined offer us the best opportunity for that, but it's a moving target. And we have to be adaptable to what might come down. I mean, it's happened so many times in different cases. The Court of Justice delivers a judgment in the middle of things, and you have to change course. And so you have to, I think the answer is you have to now deal with it on a broad brush approach, because new regulations will come in, regulations will be amended. These things just will happen, and there's nothing you can do to stop it. And it's also because of the myriad of litigation being taken throughout different member states and different references. And even in Belgium, the Market Court handing down a judgment against IAB in real-time bidding that certainly we in Ireland will try to rely on, even though it's not a European decision, and we'll say that, well, you have to give this due attention because it's the decision of a member state, whether it's a Court of Justice or not. I think you're going to see that cherry picking. It'll almost become like in the States where you have different district courts in different parts of different states, then you have 11 different circuit courts and they all have different decisions. And in that instance, unless the Supreme Court has made a definitive judgment on it, everybody's arguing different judgments from different districts and circuit courts to try to say, well, you should apply this for this reason and not this. And then the other side is saying, well, actually, you shouldn't apply this for this reason. And so it's going to, I think, oddly, contrary to what it should be doing, it will cause fragmentation in the first instance at the member state court level, until the Court of Justice then gets involved and says, this is the case. The problem with the Court of Justice decisions as they are now is they can be very wishy-washy. The Bindle case was the first one where they said, oh yeah, that is deserving of €400 compensation. Otherwise, they were just going, well, a breach per se doesn't give right to damages. You have to show some damage, but it doesn't have to be tangible. What does that mean exactly? And Bindle was the first time they said, here, take your €400, we're very sorry. And so more of that, please.
Yeah, but quickly, maybe, sorry, but what you say, okay, there is still uncertainty, but I don't know whether there are judges or would-be judges here in the room. The good news is it is being done, what you just said, presumption of harm, broad brush, all this, it is already being done in other areas of the law. So it's just, I think it will require also some help. I don't think the regulator can solve this. The courts can, but it will require the courts to be, let's say, to think out of the box and say, how can we make it happen? And by the way, it is not that revolutionary, because look, in other areas of the law, that's how they do it, and it works. And then it can be endorsed by the regulation, like we had with the presumption of harm in a cartel. No, it's in the directive. I think it's so. If there's any would-be judges here or judges think out of the box, it is not that dramatic. The basis is there.
I mean, I think we're all a little bit judge, jury, and executioner in our hearts. But, I mean, I think as a point of principle, we don't really want a breach so egregious that it's a slam dunk. I mean, you live for this nuance and the flexibility, Sean and Max, I'm sure you do. To move on a little bit, let's look at Article 20 of Representative Actions Directive, which states, so cost of the proceedings related to representative actions do not prevent qualified entities from effectively exercising their right. Qualified entities must be non-profit. I mean, if I was to play dumb, that looks like a contradiction. How do we square that circle? Where should the funding come from? How do you plan to fund cases? I mean, Max and Charles, I'd like you to take both sides of this. Max, you know, how are you going to fund things in the future?
We usually think about like a really broad number of options. So part of it is philanthropic, definitely. Like if we talk about injunctive relief, that's not going to be commercial funding in reality. A good part will come from our general budget, just from donations, so we can run cases just from the budget that we have. Once you get into the redress realm, like the numbers just got so big that no nonprofit can actually run this. So you will need third-party funding, and then to also get maybe Sean in here, we have jurisdictions like Ireland where there's still a law from 16-something that there is no third-party funding and it's a criminal act to get money. At the same time, EU law says you have to have an option to get funding. So there are jurisdictions that just have massive options to solve it. I can talk probably a little bit from the Austrian experience in that sense. Our consumer rights organization does these cases since 2000 with third-party funding under an Austrian opt-in regime, and it works quite well. They do opt-in, they have third-party funding, they have all these factors. And having the qualified entity, that's not in law, but just de facto, it's a non-profit organization that does that. They are also the filter for like crazy litigation to just bring stuff that actually makes sense, they're respected by the court. So all of this actually works together. And usually what they do most of the time is third-party funding that whatever, I don't know, 10, 20% of the claim will go to the funder if it's successful. And for most people, that's much more efficient than hiring their own lawyer, which is going to cost them more than 10 or 20%. So for them, there is more left over. And that's, I think, for the large cases, probably a system. What's interesting that a lot of countries now implemented is not just a percentage idea, but that there is a fee, so to say. So for example, in Ireland, it's capped at 25 euros per person that we can charge as a fee for the litigation, which then can, part of that could go to the funding. Or in Austria, for example, is 250 euros, just to give you an idea that two jurisdictions did tenfold of how much this should be. But that's all the different options, and each country has its own regime and own options, and we have to look at that carefully and individually of where to bring a case. That's kind of how we look at it, and it's going to be a mix of all of the above, I assume, in many cases.
Charles, to come to you, from your perspective, what are the considerations when it comes to funding? And, I mean, Ireland's always a special case, but there is also a various differences between the member states. Is there more need for harmonisation? How big a headache is that for you? I mean, take it fairly broadly so we can understand what the thinking is.
Yes, well, again, coming back to what I said earlier, it's the quality of the case, the facts, the qualified entity representing the class, credibility. Do we have, well, in terms of geography, so far it's been interesting to see that we've seen something similar to what we saw a few years ago in competition law. There were like the three main jurisdictions in Europe, UK, Netherlands, and Germany. And now competition law, antitrust litigation is a bit everywhere in Europe. And we think it's going to be the same with privacy litigation. It's true that since it's still in its infancy, so for us, we often struggle with, okay, but what's the amount, the quantum? We like to have at least some basis in case law, because I've often seen legal opinions of cases, barristers, or even lawyers in other countries saying, yeah, but that could be, and then they're making comparisons with other types of privacy violations. Yes, okay, if I'm a famous star and they broke into my room or my house and they took pictures of me, yes, that's obvious, but it's not the same. So I think for us, we will not wait until there is a well-established case law, because then we may have to wait a very long time as a funder to fund litigation. I think it's part of our job to also, well, it's part of our job to take risks, obviously. That's the true nature of a funder. We don't invest in the winning lottery ticket. That would be all too easy. And then it's also looking for jurisdictions where the courts understand the logic of funding on top of, let's say, the merits of the case. To see the benefits of litigation funding, we are not opposed to courts, let's say, grilling the funder to be sure that the interests of the class are being duly represented or safeguarded. That's part of the game. We don't need a blank check. Who is in charge? It's the qualified entity, not the funder. But then, and that's where you may say it's a double challenge for litigation funders, is one, privacy litigation in its infancy a lot of uncertainty. But if you also have a lot of uncertainty, and am I going to be eaten alive here by the court? Yeah. I will say, oh, I don't like funders, or you are just there for the money and I don't like you, and then you should lower your expectations. That becomes problematic. So that's where we need, I think, a conversation also involving the courts so that they understand what's the added value. Again, no blank check, yep. But we have an added value, but we take a huge risk, and that should be acknowledged by the courts.
So, I mean, when we come to the qualified entities, I mean, you said the credibility of the qualified entities is a consideration, not their relative poverty. I mean, is that a question that, I mean, to be a credible qualified entity, you presumably need backing to start with, so they're not the most impoverished? I mean, I'm being very simplistic about it, but I want to hear Charles first, and then you, Max.
Well, you know, I very often, I'm not a big fan of Formula One, but it's easy to use that comparison. I mean, I'm providing fuel. He has a great car, and there are two great pilots here. He has a great car. He doesn't have fuel. Okay, that's fine. I don't mind. I can provide the fuel. It means that it's a collective. I mean, we're talking about collective actions. Actually, collective actions are it's collective work. It requires each one of us and also the economic experts, etc. So whether, I mean, for us, it's not about the solvency of the entity. Yeah, obviously, we don't want the entity to go bust while in the middle of the, but since it's not for profit, it should be protected. But we don't see this as a problem. For us, it's the credibility of the people leading the litigation, because judges are human beings. They need to have sympathy. They need, if they see Max showing up in a court, they must say, okay, oh yeah, I know that guy. I know that guy. I've seen him before, yeah. He really lives and breathes privacy. He's not this purely opportunistic person saying with huge teeth saying, oh, I'm going to make a lot of money here. Yippee. I think it's part of the litigation. You need to have the sympathy of the courts, win their hearts, and then you will win their brains. That's, I think, how it goes.
And one thing to add there, I mean, we went through the whole process in Austria to become a qualified entity, and a big part is that we also had to show our financial stability. And so you do, like, it depends on the jurisdiction, but in the ones that really check you properly, you have to be stable yourself to even get the certificate of being a qualified entity. And then we have loads of, like, you know, checks on conflict of interest, for example. So we need to show that we checked, okay, is there conflict of interest between the funder and the class, between us and the class, between the law firm and the class, between all of them, and so on. So a lot of these things that are brought up, I can tell you, at least from the Austrian experience, we really have to go into these weeds and kind of make sure that there's not even the smell of any kind of problem is around, and that then, in our hope, is useful for going into the courts, that, you know, we can prove that, and that's obvious, and it's, you know, something that is not going to be challenged. The interesting thing for me for third-party funding, which is just one of the options of funding, is that it still tries to, you know, a lot of people still try to get the smell into it, and I oftentimes say, it's like, our law firm charges for that too. You know, it's a service, you pay for service, and it's kind of funny that the funding part is always a bit, like, you know, seen a bit differently than the rest of all the players that also work in this area and have to make money with this. And that's was, to me, always a bit interesting how there is a different approach here than for all the other players that in a team, as you mentioned, you know, also have to pay their bills in the end. But yeah.
May I pick up on something that you said, Max, about how to put these cases together and the alternatives for funding. We had research, a study conducted commissioned by the Dutch Ministry of Justice a few years ago to see whether it would be viable, feasible to establish a class proceedings fund in the Netherlands for non-profit actions, because as much as I like Charles, and I know him for a long time, it is of course a very unhealthy, in a way, situation in the Netherlands right now, where all the damages actions are externally commercially funded, and there would be many cases that do not qualify for that, but bring very, very important fundamental rights and issues to the courts. So we were asked to look, could we somehow make it work with such class action proceedings funds? And for that study, we looked at similar funds in other jurisdictions like Israel. Chile has recently established one, but not very experienced, but especially in Canada, they have a long-standing experience. And it turned out there that in order for such a fund to be self-sufficient, so does it mean not to be dependent from subsidies from the government, because that was the goal, that was the object, be self-sufficient, it had to be fed from the other commercially successful action. So here we go again, back to our friend. And as long as we don't have a properly functioning commercially funded cases, our conclusion was, we couldn't set up such non-profit. It sounds contradictory, right, if I say it like, but that you need commercial litigation, properly functioning commercial litigation funding to be able to have a sustainable non-profit class action proceedings fund.
I mean, the truth of it is, and it's an uncomfortable truth, we need funding, and it needs to come from somewhere. We've been told a public fund won't work unless it is at least subsidized by commercial funding. So, Charles, you said you have to win their hearts. When does the idea of commercial litigation funding for these type of actions, representative actions, move from a moral hazard to a moral imperative? Because you said that we won't wait until the case law, but the fact of it is, unless you're allowed to fund it, that case law may never come. Because who is going to take the case that actually leads to the positive case law that stops all the infringements? So it does become a matter of right of access to the courts, including under Article 6 of the Convention, and the right to an effective remedy under Article 47 of the Charter. And it's actually a rule of law issue. How do we fund these cases? Because it is clear that they need to be brought to protect people from the tentacles of big tech, in particular in the GDPR area, and nobody else is doing it. So somebody has to do it, and they need to be funded.
I knew we'd get here eventually, Sean. Yes. Max, go ahead.
Just two last thoughts, because we're already on this topic. Two things. First of all, we also had the thinking of if there is a case that becomes overly successful, we also as a nonprofit need to see where the money goes, because we may ourselves have too much if a case goes too crazy. One of the thinking we had was to, for example, build a European fund, to take one of these cases that may just go too good, and for example, build a trust or a co-op after people, where we can, have a certain snowball effect, so to say, that the next and the next case be there. That's also for us useful if then the question is do you do this all for the money? We can say, no, we have a pledge that if there is too much coming in at some point, we actually have a good idea of how to put that back in the general public's interest, so to say. That's one thing. But I think we also, what we are trying to just develop, and we're very at the beginning of it, is also be a bit more creative in the sense of, take the Irish fee, that's 25 euros, we would usually have a deferred fee so that we only charge that at the end of the litigation, because people are not going to pay 25 euros up front and take the risk. But we said, maybe we give them the option to just pay 20 euros up front and see it as a donation if it doesn't go. And there could be a good amount of people of 10% or whatever doing that. And if you have a huge number, then suddenly you have upfront funding by the individuals, which can work. All of that we need to test in reality and see how that works. But I think there's a lot of options out there that we have to start how we can puzzle these things together, where some of it is commercial, some is philanthropic, some is of the people, some may be the fund that kind of helps another case. And altogether that could actually move stuff forward. But we'll know much more in 10, 20 years.
Right. Well, we don't have 10 or 20 years. We have 15 minutes. So I'm conscious that we haven't particularly broken down the private international law and the harmonization question yet. But I'd like to see if there's questions in the room. Can I get a show of hands so I have at least an idea? I see 1, 2, 3, 4. Right.
Thank you.
5. Let's try and get through those quite quickly. 15 minutes, that's 3 minutes a question. So
thank you. Okay, I'll make it quick. So I'm Idos Ivan Sevilla from the University of Maryland, the United States. So the impact of collective action is clear. What about some of the limits in terms of the NGOs being such an important intermediary, might have selection bias in what they choose to pursue, high magnitude versus local cases, right? So a data protection breach by a local bank in Slovenia might not get the attention that other cases are getting, and their capacities are unevenly distributed across jurisdictions in the European Union.
okay, who wants to take that one? Max?
Everybody looks at me. Okay, I absolutely agree, and it's even within the qualified entities for us a bit interesting that, I mean, we have a list of probably 100, something in that ballpark now on the European Union side, and there's not that much. And I mean, there is in almost every country, there are some now. But the selection bias is going to be interesting. Some of them have very narrow focuses, and we also realized that, for example, we're one of the only ones that think about European legislation, litigation. A lot of them have a mandate that limits them to their own jurisdiction, and then you do the same thing 20 times, which is also not overly efficient. So there's a lot of these problems. I think it's not going to be the, you know, that definitely covers all the topics, but it can probably cover more topics. Baseline, like outside of this whole panel, when it comes to the GDPR, it's generally the mandate of the data protection authorities to not even get it to a damage. We are kind of like the cleanup service when the public authorities didn't do its job in this case, which I would still prefer, but the realities of the last years is that that doesn't happen all too much. And then the next option you have is to kind of then, when the stuff went wrong, to have damages cases. So I agree with the question, and I can't really say this is the final answer. We'll see how it develops.
Nothing definitive coming off this panel. Okay, question at the back, please.
Yeah, thanks so much. I'm Maria Magierska from Maastricht University, and I have a question. I think, Max, you hinted at it at some point, but I'm curious to hear also perhaps Ianika has some ideas from the Dutch experience. And it's a question about Article 82 in collective redress actions, particularly the claim for non-material damages. As I understand now, even in the Netherlands, most of these cases based on non-material harms are dismissed by the courts, or just damages are not given due to the fact that everyone experiences the harm differently. I think you, Max, you were mentioning something about like dividing people into the groups and stuff like that, but I think isn't it replicating this narrative, which is not really actually what even the data protection now is, that there should be actually room. So that's my question. Do you think that there is possibility of the Collective Redress Directive challenging this individualistic approach of data protection, and whether we will see something perhaps like societal harm, like Brazilian-based approach to that, somehow in the future? And like, do you think there is a chance in Europe to have it?
Thank you so much. This is such a great, excellent question. As it happened, I just finished a piece a while ago, and another colleague has also written a paper that is going to appear in the next journal on the mass claims journal. We have a dedicated journal for this topic since a number of years that approaches exactly that very point, and that is that in mass infringements that relate to big tech specifically, the infringement by its nature is collective, and therefore it can only be properly addressed on a collective basis. And that requires indeed a paradigm shift from this very individual way of thinking, of approaching in the process, which is very traditional, and that's how most of us have been trained as lawyers, to a very different collective approach and a collective way of thinking. And that gives me opportunity to make 2 points that I wanted to make when we're going to talk about the Private International Law panel, because I wanted to ask first, how many of you, by raising of hands, have an experience with or would consider themselves as private international law geeks or experts or people who know their way around? Can you please just, I won't ask you anything, but just raise your hand. 2, 3, okay, maybe 4 or 5, handful.
Everyone is shy in this room. Just
how many of you would consider themselves as collective redress experts? Handful again. And that is exactly the reason why we will not have a proper functioning system until all these 3 expertises work together. The European Commission has been saying for a long time that we don't need special instruments for collective redress in private international law. And for many, many years, I was thinking, why is that? Everybody who's dealt with collective redress knows that you need separate rules. And the starting points in private international law are very, very different. They are overlapping interests, but they're very, very different. It's about legal certainty and predictability, whereas collective redress is about access to justice. And you have to get those 2 to speak together. And your point that you just made builds into that, because that also requires in the procedure a departure from the 101 way of thinking and a different approach to damages, the aggregate damages, and everything else. So thank you, excellent question. I hope I answered it, but that is the best I could do now.
If I may chip in, like very short as far as possible, to probably touch on both things. So we, for example, if we think we bring a case in Ireland, let's say, the private international law, because they're all consumers, basically means the national law of 30 jurisdictions is applicable. So the Germans have their damages probably calculation or statute of limitations applicable, and the Austrians theirs, and the Irish theirs, and so on. And like even the statute of limitations is 2 years to 30, dependent on which country you're in. So you have this in the group, which is the private international law element, one of them that we're dealing with. So it's quite complex when you go into it. But going back to the question, I think we really are very much determined that we have to go to the objective assessment. And again, it's a bit back to the broken bones example. If someone is just crying for 3 years long because of their broken bone, they don't get more money than someone is like, I'm the bravest person ever, I don't care about the broken bone. They all get exactly the same amount of money in most jurisdictions. And one of our colleagues we talked to was like, in Ireland, there's apparently a broken bones table, they told me, that informally is known in Austria, same thing. So it's interesting that in very different jurisdictions, we all came to this objective assessment. And my hope is that we don't reinvent the wheel in the GDPR here and say suddenly there's non-material damage that we have to assess totally different than all the other non-material damages that we do. And that combined with the efficiency of really bringing a case will probably get you to the answer of having more or less case law that gives a certain token amounts, I think in the three-digit realm somewhere, which would probably be the reasonable approach. If you then compare it to the broken bone, which you also have to say how much is your access request that wasn't answered compared to that.
Let me see the hands again. Who have we got? We've still got 1, 2 here and one at the back. Have we? Yep. Hands up. I see 2. Yes, one there in the middle and then one there at the edge. And then I think we'll probably have to wrap it up.
Yeah, thank you very much. It's Baybora from Leiden University. And I would like to ask, how do you see BCRs as a legal tool? Are they sufficiently efficient, considering that many multinational group companies face most likely the collective redress litigations? I mean, do you have any suggestion to improve those legal mechanisms? How do you position them, find them in practice, the BCRs?
Finding corporate rules?
Yeah.
BCRs? To be frank, with collective redress, we don't have any overlap there. Like usually I see them as a different version of SECs. I don't know if there's much connection right now.
Maybe follow that one up bilaterally.
Yeah.
I don't think we're equipped in this panel to tackle
Yeah,
it.
I mean,
Yep.
yeah.
I'm Stuart Dresner from Privacy Laws and Business Reports. And my question is simple. In your experience, which national data protection authorities are most supportive of your collective action work? Perhaps as some quiet advice or maybe helping in court action?
Well, this was going to be something we didn't quite have time to. We're going to talk about jurisdiction shopping and we are going to talk about fragmentation. So well, let's use this as a final kind of round for people to comment on that before we break
I'll
up.
quickly answer your question and try to answer yours at the same time. So we see both. First of all, they're supportive in the sense, oh God, Lord, we don't have to deal with that anymore and the courts can deal with it. But that is also the reason why some of them are not so happy because, let's be frank, a lot of the big ticket questions will go to the courts and not to the data protection authorities anymore. And that also undermines their jurisdiction and role in this whole game. But it's to a certain extent, caused by not doing much in many cases. And then, people find other ways and go to the courts directly instead of the data protection authorities. And that gets probably to the forum shopping this question that we had before. I mean, on our end, we take the fundamental view that most of these companies we litigate engaged in forum shopping in the first way of going to Ireland with, not paying taxes, or Luxembourg or Netherlands for the copyright tax exemption there. So we usually follow them. Mostly we're probably going to litigate at their headquarter, which is always a downside as the qualified entity. But that being said, there are hooks for jurisdiction all over the place. So for example, wherever the damage occurred. So for injunctive relief, we can go in Vienna to the local commercial court, which is 2 stops on the subway, and then they have to fly over and speak in German and bring the case. So suddenly it's interesting because you have much more jurisdictions and you can be much more selective of where you want to go. And that's the right of the plaintiff to choose between the 2 or 3 jurisdictions that the law provides, and then pick the one that's the most favorable for yourself, or especially also the most efficient and cheapest one, because we do have countries where it takes 10 years until you have your case heard. You're not going to go to that country first. to bring your case. So that's a bit how we approach it.
I just wanted to use this as an excellent example of the point I made earlier, which is how the different disciplines do not speak to each other. Because in private international law world, forum shopping is something negative that should be avoided. In collective redress world, that is perfectly fine, because I want the best value for my money. And that is, as a consumer, when I buy a product, I'm also comparing where I can get the best product for my money. And when companies are setting up their offices, they're also looking at where can we get the best value for our money. So there is, in my view, no good reason why when we suddenly come to collective redress, we should view that as something negative. If it's, then it's the qualified entities or the representative actions that are the ones that are forum shopping. So from now on, everybody in this room, forum shopping is a good thing.
Okay, I'm going to go for a final round of takeaways. I mean, one of the sort of, if you like, overarching questions we came to this with is, why aren't there more cases of this nature? Because we thought there would be, and that's kind of, we've tackled a lot of that. And if we assume that there are still breaches and infringements and breakings of the law, will there be more? I'm going to ask that question to go along the line is, do you think we will see, I mean, Max said 10 to 20 years before we're going to see kind of an overall picture, but what is your level of optimism or pessimism in terms of what we'll see for the future? And make a brief prediction, Sean.
Well, as I said, I think they are going to tick up because the actions, I mean, I think there was uncertainty about the transposition of the directive in a lot of different countries, which stalled a lot of different entities. Then you had to apply to be a qualified entity. So you had to go through these stages of procedure, and then you had to identify the correct first case in your own jurisdiction. So I think it has been gently catchy monkey for the first number of years about this. But as I said, I think in Ireland specifically, you're going to see between 2 and 5, maybe 6 in the next 6 months. And then that will determine if we can do them effectively and efficiently. Then because of the tech companies being headquartered in Ireland, you may see other people passporting in who are qualified entities elsewhere coming in and going, we can do this in Ireland. A lot of that's dependent on the funding thing. But it's going to move much quicker now.
Max, continue this story for us, please.
I would join in, and I would say, you know, we have, I think in this panel, we had these 20 puzzle pieces you need to do, and each one of these puzzle pieces will probably be fixed gradually or improved in the sense that, you know, to give you a simple example, to have like an onboarding system that works better than the one we used the year before, and then, you know, each puzzle pieces may improve to like get this up and rolling. But I agree, like there was much more expectation that like the first day everybody's going to hit the ground running. The reality is people, also the NGOs that work on that, have to kind of gradually get used to it. There's a bit of a first mover issue. Everybody's like waiting for the other one to go first, but someone does then, and then usually I think there's going to be a certain dynamic, and we generally feel that there is a lot of room for improvement that can then really speed that up year by year to become more of a thing.
I'm also optimistic. We've seen huge learning curve already among in Netherlands in the courts about these topics, and also among all other parties and players involved. So I can see how that is getting better and better.
And Charles, I loved your recommendations. I mean, let's say if X, then Y. So if these your recommendations, or some of them actually that you've thrown at the wall, stick, what's your expectation?
Well, rather than an expectation, I propose a plan.
Okay.
If we want to improve and to build something, you always start with the foundations. And I do hope, as a funder, I would rather say, okay, as a funder, I would rather be interested in funding a case that's maybe not the largest one, billions of damages, potential huge funding fees in case of win, but one that will be, of course, profitable, otherwise I cannot fund it, but to lay the foundation. And that means starting maybe with more obvious cases that are easier for the court to embrace and to use to build good case law, so that we can then, brick by brick, build a wall to protect us against breach of our privacy rights.
That's a lovely image to end the panel with. So thank you all very much. Thank you for your attention. Can we have a round of applause?